we know that caregiving hits everyone at one point in the stage. And so throughout this conference, you will hear how you can get connected, get all the resources that you could get provided. And so without further ado, let me turn it back to you, Kara.
Thank you. I am going to, sorry for the herky-jerky here. I'm going to spotlight Amanda. And then remove spotlight. Okay, now I'm going to introduce Amanda. I'm sorry, you're in the middle here. Amanda Singleton is the managing attorney at Singleton Legal PLLC in St. Petersburg, Florida. As an AARP family caregiving expert, she writes and speaks on financial and legal issues that affect caregivers, a subject that has defined her personal and professional life since she was 30, when her mother was diagnosed with cancer and immediately required full-time care. She is going to speak on legal topics for family givers, and I'm going to let Amanda take it away from here.
Oh, thank you so much for having me. Good morning, everybody. Let me see about sharing my screen here. All right. So yes, our topic this morning is legal topics for family caregivers. So bear with me while I get comfortable with moving the slide deck through. It would not be a legal topics discussion without a disclaimer. This presentation is intended to provide general guidance, not specific legal, financial, or health advice, because your individual circumstances may differ. So take into consideration your life before you take any action on what we talk about today. And I highly recommend you consult professionals for advice regarding your personal situation, because there is no one size fits all. This presentation is recorded, so be considerate of sharing your personal, legal, financial, or health information about you or your family members in the chat, or if you have an opportunity to speak in the webinar. Okay, so let's get started. Today's program is about legal topics for caregivers. So we're going to go from high-level information down into specific issues and a lot of resources that you can use, some of which will be discussed in further detail later today in other programs. So we'll save time for questions. Again, general questions are great. Specific questions I cannot answer, as I am not your attorney, and we'll provide this presentation and links to everything. So don't feel like you have to take notes, just listen and think of some questions that might benefit you or other people who are participating here today. A few ground rules: share the floor so everyone has an opportunity to ask their questions. Mute your microphone if you're not speaking, but I think that you all may only be in the chat this time. And keep the chat open and active. And lastly, this is a judgment-free zone, so feel free to share freely. So AARP's mission is to help all family caregivers. I'm guessing that some of you are not retired people. However, AARP's mission is to empower people to choose how they live as they age. And that means family caregivers of all ages are important to that mission. And as a family caregiver or an expectant family caregiver, it may not be in your life now, but it will be at some point, you can help empower other people to choose how they live as they age. And we know that's a challenge at AARP, so we are here to support you in that. Kara introduced me, so this is my introduction slide. My name is Amanda. I became a caregiver when I was 30, as she said, and since then have been a multi-time family caregiver. I've devoted my career since that time to representing and advocating for unpaid family caregivers. My contact information is below. Feel free to reach out to me at any point. If you need any resources, I am happy to connect you and get you pointed in a direction. So do not hesitate to reach out. Little agenda slide. Why is this important to discuss? Why are legal topics important to discuss if maybe you're not in the caregiving process yet? Because caregiving can call for us unexpectedly, and sometimes it can creep up on us as we don't even realize we are slowly becoming a caregiver for our elders. So most caregivers at some point find themselves struggling to balance their home life, their work life, their caregiving life, and all those commitments become a little bit too much. So to ease that burden, everybody really should plan ahead, and specifically with regard to their legal affairs and financial affairs, because proper planning makes that transition into caregiving, whether it happens in a day or over a period of years, you suddenly realize, oh, I'm a caregiver. The legal planning, the proper planning makes all the difference in the world. That's because caregiving is nearly universal. Most people don't necessarily self-identify with the term caregiver. They are just being a good, good daughter or son, or just a spouse or a partner. But to get an idea of who's a caregiver, I'll ask you a few questions. If you do any of these tasks, you are probably a caregiver. So if you help people with their household tasks like laundry and yard work, you cook or provide food for family or friends, you drive people to doctor's appointments, make the appointments, or run other errands, if you communicate with their doctors, coordinate their medication or their appointments, or you help them with their finances and making sure that their bills are paid and organized, all of that is caregiving. So give yourselves a hand if you haven't identified yourself as a caregiver yet, but you do these for somebody you know and love. And it really shows the importance of that quote in that slide, that there are only 4 types of people in the world: those who've been caregivers, those who are currently caregivers, those who will be caregivers, and those who will need a caregiver. It's truly something that all of us will do. And the reality is, over the course of our working years, we're likely to be in all 4 of those groups, often more than once, and sometimes overlapping. So even though the caregiving experience is universal, it's really a secret second job for a lot of people. Most caregivers are part of the workforce. 6 out of 10 family caregivers are working, and 73% of them are taking care of somebody at home. So the majority of working caregivers end up in a struggle of balancing work and caregiving. And most of them report that they are having a hard time with it. So that can make it incredibly stressful, both at home and in the workplace. And this is where planning comes in. Planning really matters for easing the transition and easing that time frame when we are in our working lives and our caregiving lives. 90% of people say it's really important to talk about their end-of-life planning, their wishes, and do their legal documents. Over 80% of them say, yes, legal documents are really important, but only 40% of people, less than 40% of people, actually do their documents. And that number has remained steady for as long as I can remember. So I'm hopeful that today we can start to shift that number up. And if you haven't done your planning and your loved ones haven't done your planning, that you consider putting it higher up on the priority list than it may have been in the past. And why? Planning for life and death is really powerful. It spares you and your care partners a lot of unnecessary headaches, burden, expense, and heartache, really. And if you're a caregiver, it means that you and your care team know that you're making the decisions that your loved one wants or would have wanted. And if you're planning for yourself, you're keeping yourself as the captain of your own ship for as long as possible, to age independently, to age at home, things like that, that are really important to people, but are much more likely to happen if you plan ahead. Planning ahead reduces uncertainty, it reduces conflict. A lot of times when there's major medical events in people's lives or a family member needs caregiving, it tends to raise some conflict among the people in their circle. Planning ahead reduces that and reduces the risk of having fractured relationships, or even worse, time in the courtroom. So planning ahead does prevent litigation as well, which as a lawyer, honestly, we love to prevent litigation with what I do for a living. So planning ahead is a huge piece of that, because in the absence of planning, that uncertainty breeds conflict and possible resentment and possible court involvement. So planning ahead is crucially important for a variety of reasons. I'm going to leave this slide up for a minute so that you can kind of take a look at it. And I think that the slide deck will be provided at the end of the day. This list is a great place to start thinking about your planning and thinking about the planning of people you're either caregiving for or you're expecting to be caregiving for. So it covers a variety of topics, your legal and financial affairs. Some you may not have thought of yet, and some you may not know why they're important, but everything on here is extremely important to having a comprehensive caregiving plan. So take a moment to read them. If any of these have not been done or you don't even know what I'm talking about in this list, put it on your to-do list to explore it a little further and use this as your roadmap to get started. Moving on. So breaking it down, what we're going to talk about today is really 3 parts of legal topics for caregivers. The first, we're going to talk about life care planning. So have you structured things? Do you have the right documents and organization in place so that you're prepared as a caregiver or your family members are prepared to caregive for you? Everybody needs to be able to hit the ground running, if at all possible, at the time that caregiving calls. The second piece is post-life planning. Have you structured your planning so that your loved ones spend less time in court and less time dealing with the business of death if you pass away or your loved one passes away? And 3, and really so important, is communication. Have you and your family members or loved ones that are going to be in your caregiving circle clearly communicated as a team? So it's important for the care recipient to be able to convey what they've done, what their plans are, and what their expectations are. In the absence of that, sometimes we don't have the opportunity to do that. And then we have to try to figure out and reverse engineer what would this person have wanted. And it's not ideal. So talking through all of this before events happen is just as important as making the legal documents. So the caregivers themselves will be so much more effective. They'll have better peace of mind knowing that they're doing what the care recipient would have asked of them at the time. So all of this is important for you, again, as a caregiver, but also for your care recipients. When you're thinking about these documents and what to do after these sessions today, don't only think about the people that you are caregiving for or might be caregiving for. Think about yourself, because you are a part of this too. All right, moving into life care planning. We're going to talk about a few documents, and they're really important for everyone to have. Life care planning is for everyone. If you are over the age of 18 years old, I want you to consider having these documents. If you have children who are over the age of 18, they are not your children anymore in a legal sense, that you can't just do things for them in the event of emergencies. You do truly have to have these documents. And so everyone who has competence, meaning that they are able to understand the document that they're signing, should consider having these really from the moment they become the age of majority. So not just your elders, think about your descendants as well when you're doing this part of the planning. So life care planning, like I said, is just part of a transition into adulthood. It's like planning for retirement. It's like scheduling your own dentist appointments every 6 months. This should be considered just as important as those things as we are aging up. All right, so the first document is called a healthcare directive. And every state has a different term for this. And there aren't 50 different terms, but the terms do vary among the states. So you may know it as a healthcare power of attorney or a healthcare proxy. In my home state of Florida, we call it a healthcare surrogate designation. So I'm used to that, so that's how I'll refer to it. All this document does, it appoints a person who can receive your medical information, meaning they can look at your charts, they can review your records, they can talk to your doctors, and they can make medical decisions for you, but only if you cannot. So long as you're capable of providing informed consent to your medical providers, that is what is going to happen. The healthcare directive comes into play at a point where you may not be able to communicate your wishes. Your surrogate is the one who will do that on your behalf. So I think I just went over this on the slide may be a little repetitive for what I just said, but yep, your surrogate has the authority to do these actions without legal intervention, meaning that a court does not have to say it's okay for them to do it. The document is the authority to do it. So giving informed consent to procedures, diagnostics, reviewing charts, and even in including refusing life support or consenting to it if you have not covered that issue in another document that we'll talk about in a moment. Like we said, everybody over the age of 18 should consider having these. You do not necessarily need a lawyer to create your healthcare directive. There are state compliant forms online. AARP has an excellent resource online. I'll put up a code for it later in this presentation and a link to it in resources. But if you just Google AARP free advanced directives, you will find forms for all 50 states and the US territories. And you can do these documents today without a lawyer. If you have questions about them, however, I do recommend consulting with a lawyer to do these documents because you don't want to make them and misunderstand what you've been doing. These are not documents your doctors create. These are not documents your hospital creates. However, if you have ever checked into a hospital, you may have found that a healthcare form was in the intake paperwork. The hospitals typically do not tell people to do them or require them to do them, but this document can also be found a lot of times when you're admitted to a facility for some reason. In the absence of this document, there is going to be a default law in your state that says who gets to make decisions for you in a medical setting if you cannot. And the problem with that is that sometimes it's not the person that we would want doing the job. Here in Florida, it's a flow chart. It's next of kin going down a list all the way to a trusted friend or even an employee of the hospital. And for family members who are estranged or fractured relationships, things like that, they very well could end up at the controls in the event that a family member is incapacitated. And so the healthcare directive can prevent family members we may not necessarily want, or even all the way down to an employee of the hospital we may not necessarily want making the medical decisions for us. Oh, let me address this question really quick before I move on. When can your surrogate start using this document? So I mentioned a moment ago that your surrogate can't make decisions for you until such time as you can't provide informed consent. However, most forms do have an option that allows your surrogate to help you even though you still have capacity. So I feel like this is a really important thing to note because for caregivers, a lot of times we're the ones who are making the phone calls. We're the ones talking to the doctors. We're transcribing notes and we're the advocates in the medical setting. It doesn't mean that our care partner may not necessarily be able to consent to what they agree to and what they don't agree to. So healthcare surrogate forms do have sections that say, my surrogate can act for me now. They cannot supersede my decision-making though. So that is an option as well. And if you're really in active caregiving, can be very helpful to make sure that communication lines are open with doctors, insurance companies, and so on. To choose a surrogate, reflect on this. It may be an easy decision. It may just be, my spouse, my partner, my siblings, my children, have, just obvious choices for you, but sometimes the choices aren't that obvious. Of course, they have to be an adult. They have to be over the age of 18. But think about who would be your likely caregivers, who would be the ones who would come to your bedside and help you in the event of an emergency. And, can they handle it? Are they a good advocate? Because in my experiences and stories I've heard from caregivers in the last 15 years, you really need to be a squeaky wheel sometimes to get things done. So that is a good quality to have as a caregiver and sometimes just necessary to get better treatment and better outcomes. So, and then importantly, do you trust your surrogate? Do you think that they'll make the decisions that you would make for yourself, or would they act in their own interests? Things to think about. And then one more thing to think about as well. When you're choosing your surrogates, you may think, okay, well, I have 2 children. I'm just going to put them both. And that's fine. Legally, you can do that. However, I want you to think down the road and imagine what would happen if there was a conflict among your joint surrogates. If they can't agree, they're in a stalemate. The only option is to mediate it, to take it to court. And meanwhile, there's a person whose medical care is on pause. So I would recommend when you are considering your surrogates, consider naming them in order. Name one and then an alternate if the first one cannot or is unable to act in that job. All right. Life care document number 2 is a companion to the healthcare surrogate. It is called a living will. It has nothing to do with your money. It has nothing to do with a last will and testament. A living will is your expression of your wishes for the medical care you want at the time of your passing. So if you are in the active dying process, if there's no probability of your survival, then you have an opportunity to tell your doctors what you want. And that is such a gift to your family members because they will not be having to make those decisions during an incredibly tender time. And so the living will document sometimes can be combined with the healthcare surrogate. You may find it in one form, or it can be its own separate form. So it can include so much more than the treatment that you consent to or not. It can be just as simple as saying, if I'm at the point there's no probability of my survival, it's been confirmed by 2 doctors, then I wish that life support not be continued because at that point, it's only going to prolong my passing, not save my life. It can include a list of every single procedure you consent to, and not every, because we can't. It's impossible to contemplate all of that. But some of the ones you would expect, like artificial hydration, intubation, dialysis, things like that, you can be very specific with it. You can include organ and tissue donation, anatomical wishes. All of that can go into the living will. And even some softer things like music you want played at your bedside, or you want to be able to have your dog come visit, whatever it is, all that can go in there. So it's a powerful exercise to make your living will. It can be as simple as you want, and it can be as specific as you want. Considerations for your living will. Who should consider having one? Everyone over the age of 18. Do you need a lawyer? Again, not always. There are excellent living wills online, again, ranging from very simple to everything you could think of under the sun, 30 pages, you know. If you don't have one, then again, there's the healthcare proxy law. There are family members, you know, the list of folks who can make the decision at what point to discontinue life prolonging procedures. And in that case, it is possible that family members will disagree. And in that case, then they do end up in front of a judge. So it is a powerful exercise to have. And again, it does keep you in control of what happens with you up until the day you die. So this document is only used at the end of life when the person can't speak for themselves. State laws vary on them, so check your state law for more information. And you might be wondering, is this the same thing as a DNR? Is it the same thing as a do not resuscitate order? Or in other states, we have MOLSTs, POLSTs, POSTs. There are lots of different names for them. No, the living will is a legal document. A DNR is a medical document created by your doctor. They do not necessarily conflict at all, but lawyers don't create DNRs and doctors don't create living wills. When you are doing your reflections on creating a living will, think about what really matters most to you at the end of life. Do you have specific spiritual, religious, or familial needs? Your specific religion may have its own document. It may have its own advance directive. So it may be worth asking if you have a certain faith, if there is one that is used. Think about what interventions you feel right about, or what you would not absolutely refuse to have in the event that you were in the dying process. And then just think about what dying well means. Would you prefer to be at home? Would you prefer to be in another setting? Things like that can all be very helpful for your loved ones at the time of your passing. The third document is a companion to the living will and healthcare surrogate. What the healthcare surrogate does for your medical life, the power of attorney does for your legal and financial life. Again, we call these life care documents because they're only intended to be used during your lifetime. And that durable power of attorney is going to appoint someone who can handle your legal and financial affairs for you if you cannot. This is the most important tool in the caregiver's toolkit, because a lot of times caregivers do not have the authority to do things that they need to do to keep the gears of their care partner's life going. And that can be something as simple as making sure that the electric bill is paid if somebody's hospitalized, to applying for Medicaid and getting them enrolled in a facility after a hospitalization. So it runs the gamut. Everything you can do for yourself, your power of attorney should be able to do for you. And a lot of times when caregivers don't have this document, they do end up basically having to do things that are not necessarily okay. Like I, for example, pretended to be my mom on the phone multiple times because her cancer took her voice, and like immediately. And so I had to pretend to be her on the phone to like inquire about insurance or get the electric bill paid and things like that. And that's technically fraud, and we don't want people to have to do difficult things like that. And so the power of attorney, again, is important for everyone over the age of 18. Remember, in some states, the healthcare document is called a healthcare power of attorney, completely different than the durable power of attorney, although it can be embedded into one. You can have a durable power of attorney that has medical embedded in it. So like I said, every state, the documents look a little different. I don't know if any of you alumni are in Florida, but in Florida, we have a really quirky power of attorney rule. So make sure that if you are in this state, or really any state, that your documents are the compliant documents for the state that you're residing in, because they may not say what they need to say if you're trying to use it in another state, for example, if you move. So make sure that your documents are always state compliant. Considerations for power of attorney. Everyone should have one over the age of 18. Highly recommend utilizing counsel for these documents because pre-printed and online forms may fail to provide the right protections. They may not give the right authorities that you need. And if you don't have a document that says what you need it to say, then it really won't be accepted by a financial firm or a title company or whomever. With these documents, the standard is typically, if it doesn't say it, you can't do it. So it's really important to get them right when you're making them. And so if you don't have one, what happens is that your loved ones may end up having to get a guardianship, which is a court process. And I'll talk about them. I'll touch on those a moment later. But a guardianship is a much more restrictive and expensive process to undertake. And so the recommendation is always to do your planning first, for a variety of reasons, but one being, just the cost and the burden of having to go through a court process. So the durable part of the power of attorney means it can be used up until the day you die, even if you become incapacitated. We don't recommend making this once and then never thinking about it again. Make sure that your life care documents don't go what we call stale. 10 years goes by. Consider updating them. Not only because we want them to be up to date with the most current laws in your state, but also because your relationships may change. People die, they get divorced, they become estranged, whatever it is. And the people that you've named 10 years ago may not be the people that you want today. Similarly, children grow up. You know, at some point, if you have descendants, then they can step in and do this job for you, whereas you might not have named them when they were younger and unable to do so. For choosing your agent, they should be an adult, and it should be somebody you do trust, because they are getting the keys to your life. They are going to be able to handle your affairs, and so your power of attorney needs to be a person who understands how to act in your best interests. They become a fiduciary of yours, which means they're held to a very high standard of conduct. So if they are exploiting you or taking money from you for themselves, things like that, they are subject to criminal and civil penalties. But we want to start by selecting powers of attorney that we trust. And so they're called our agents in our power of attorney. And your agent doesn't necessarily need to be a family member. If you have a trusted friend, advisor, someone that you think would be really good at this job, it's okay to name them. You just have to remember that there is an intersection between your healthcare life and your legal and your financial life when you are needing caregiving. And so your healthcare surrogate and the agent in your power of attorney are going to necessarily need to work together. So when you're naming those people, consider how they would work together. If they don't like each other, they're not going to get any better, not going to get any better in a time of crisis. And so really kind of think about, imagine how it would all look and make your decisions from there. In the absence of having your life care planning documents that we just talked about, the alternative is to have a guardianship or a conservatorship. These are court-appointed people who will be able to make decisions about your person, that means your medical life, or your property, that means your money and how it's spent. So under those circumstances, the guardian would be put in place, and that is an ongoing process. And so if we can avoid it, it is the preference to avoid it. The guardianship and the conservatorship are much more restrictive and costly than just having your documents done. Post-life planning. Caregiving doesn't end when your care partner dies, and it can go on for months or even years after the fact to handle somebody's final affairs. From cleaning out their home to paying off their creditors, distributing inheritances, dealing with the probate court, and with proper planning, this can all go so much smoother for your loved ones. And this is truly a gift too, because it allows them to focus on what's really important as well, you know, and be with their grief and be in mourning and not be so enwrapped in the business of death. So encourage yourself, encourage your loved ones to do thorough post-life planning when the not when the time comes, as soon as possible. And so post-life planning not only includes your documents that we're going to talk about, but so much more. There's a lot of homework that you can do to make things easier. And I'll refer you back to the organizational checklist I gave you earlier. Sit down with that, and that will really help you get a comprehensive post-life plan going. No one size fits all. I get calls a lot. People say, I just need a basic will. and you know what? They don't. They need a lot more. And, you know, some people really do just need, you know, to make sure they have transfer on death designations because they only have one checking account. So it varies dramatically per person. Everyone should have a will as a safety net to catch anything that they may not have gotten to in their post-life planning. And a trust can be helpful in some circumstances. It is not an always must-do document, and there are many different types of trusts, which we'll touch on in a moment. And then again, talking about the homework that you can do. Deliberate, thoughtful planning for your beneficiary designations on any accounts that you have, payable on death designations on certain accounts, transfer on death deeds on your real estate if that's possible, creating companies like limited liability companies or otherwise that can pass property and businesses seamlessly without probate court. All of that is on the table for your post-life planning, and all of it should be considered. So let's talk about a will and what it does. A will is a written direction that controls what happens to your property and for your guardians of your dependents at your death. And you can change your will at any time by drawing up a new one. But if you have a current will, please do not write on it. Writing on your legal documents can create a whole mess of litigation. I do not recommend it. Keep the original of your will safe. Your state might even have a registry where you deposit your will in advance with the clerk of court. So make sure you know what's available to you in your state of residence. Using an attorney to create a will is the recommendation. Using self-generated tools can run into some problems. They may not meet the formality requirements of a will in your state. They may not be thorough enough. They may not say what it needs to say. I will share that my mother had an online will and I had to probate her very, very little of what she had. And it was so unnecessary. And it's part of the reason why I do this for a living today, because I learned in that process, oh, you know, it didn't have to go this way. It could have been easier. So when you're doing your planning, really think about every way that you can make this as easy as possible for your loved ones, and don't do what's as easy as possible for you today. When you have a will, store it in a safe, accessible place. A will that we can't find is just as good as having no will at all. Some attorneys do retain original documents, and like I said, some states do have registries. You know, the best place to keep it is where it can be found and where it is safe. Some people even keep their wills in their freezers. And I had a 100-year-old client I told that to, and she said, oh, frozen assets. And I love to tell that joke because she was so quick on it. Also, your financial advisor may have an e-vault where you can electronically store your documents. And if they don't, just make sure your financial advisors know where you keep your documents as well. Okay. A trust is not always necessary, and they are used for a variety of circumstances, to control where money goes, for tax planning, for making sure that people don't get kicked off of public benefits if they receive an inheritance. Lots of reasons to have a trust. Not necessarily everybody needs one though, okay? So a trust is created by you to manage your assets during your lifetime and distribute the assets after your death. And it can have conditions on who gets what, when, and how. A trust, when it is well drafted and when everybody does their homework and fund the trust appropriately, is an excellent planning tool. But an unfunded trust, a trust that's just a document with no follow-up, is not as good, not as valuable as it could be. So sometimes the trust actually makes it more expensive instead of less expensive to handle somebody's estate. You may ask, what happens if I don't do a will or a trust at all? Your state is going to have what's called an intestacy law. Having a last will and testament means you die testate. Not having a last will and testament means you die intestate, and the intestacy law takes over. And that will say how your estate will be divided. That can have really difficult consequences sometimes, particularly in cases where you may have a marriage, but also children from a prior relationship. Those folks may end up splitting assets in a way that you wouldn't necessarily want. If you have 30 nieces and nephews, and I'm not making this up, this has happened in my office. If a person had 30 nieces and nephews, but no other relatives, those 30 people can inherit one piece of property. And can be a real disaster, you know, because no one's going to agree on what to do with it. If you don't have these documents, then it's leaving it up to chance on who's going to be the executor of your estate. And then ultimately the court may be choosing to appoint people or taking control of an estate that just goes way too conflict driven and complex. So having the documents, again, it's a bit of control and making sure that things go easy after your passing. All right, to keep you all moving the ball down the field for yourselves in the next week, choose one of these experiments to do. I won't read them to you, just take a moment to read them. And maybe have an accountability partner with this and say, I'm going to get this done in the next week. It is a small step forward on my caregiving legal planning. So pick one and knock it out in the next week and make sure to report to your accountability partner that you got it done. Okay, moving on. So we've talked about the legal documents, and I'm sure we'll talk about them a little bit more in Q&A, but we're going to talk about communication now and why it is so critical to talk about caregiving before caregiving is a part of your life. That's my mom. So my mom, I called her Cookie. She was 60 years old and I was 30. And she was a single lady, you know, just got back from Europe. She worked 3 jobs. My mom was out there living her life. And she called me from the hospital one morning and said, I'm at the hospital and they think I have brain tumors. Can you come? And by that night, I knew that she would be diagnosed with metastatic cancer based on the scans they had done post brain surgery, and that her prognosis was going to be very poor. And almost immediately, she lost the ability to walk, to talk, to eat, to speak, to really perform any activities of daily living. And she wasn't expected to live 6 weeks, but she lived for 1 year and 3 days. Which was a miracle for me. And in that time, she regained the ability to talk, to walk, to eat, to speak. It was all, you know, really beautiful that she came back around and rebuilt those things, but ultimately did pass away. And one thing that, despite my mom having a PhD and me having a law degree, she didn't do her planning the right way. But we did have lots of conversations because we talked all the time. And she was not afraid of these topics. She just didn't do the steps to get it done because I think people don't think at 60 that that's going to happen. So, you know, I knew what she wanted, but it was a harder caregiving experience for me. And it was a harder post-life experience for me, like I said, having to probate for her. And the biggest gift was knowing what she would have wanted and being able to carry that out. But I don't think a lot of families do have those conversations. So I strongly encourage you to. In the years since caregiving for my mom, I've been a caregiver multiple times, and people generally do not talk about these things, and a lot of times they don't do the planning. And I will tell you, as far as communication goes, we'll talk about some techniques for communication, but the one thing I want you to see as the biggest red flag is if somebody says everything is taken care of, I promise you it is not. So dig a little deeper in your conversations. Here are a few tips for conversations starting. Family members can be very reluctant about talking about these things, so think of this as more than one conversation. Open the door, use some of the resources that we're going to have in the rest of this slide deck. I want to leave time for questions and answers, so I'm going to move a little quicker through the next few slides, but you'll have access to all the resources. And just make sure to come back to this if you feel like you don't know how to start the conversations. There are a lot of great resources in here to show you how to do it, and even some online scripts that you can use when you're addressing things with your family and loved ones. All right. Does anybody have any questions? I'm looking in the chat right now.
Amanda,
Yes.
we have some questions in the Q&A. So the first one is outside of dealing with the court system and associated costs, is there an advantage for pursuing guardianship versus power of attorney?
Well, I will say that with guardianship, you have so much court oversight that, you know, in the event that there's a very high conflict family, anything that happens, anything that transpires would necessarily have to be brought before the judge or magistrate. And that might be a comfort for some people, but I would say that having the power of attorney, having that legal authority, that's all you need. And then you have to handle your interpersonal relationships, effectively yourself. I would suggest that that would be the preference versus having to bring all family matters in front of a judge.
Thank you. The next one comes from Kimberly. Do you have to transfer property ownership under a trust from the current owner to the trust? Does it get complicated when you have a mortgage?
So there are lots of answers to that question. There are lots of ways to do things. And yes, you do have to always take into consideration mortgages when you are transferring property. You don't want to do something that has a mortgage company call your note and require payment due now. And you don't want to make mistakes with regard to paying the right amount of taxes when transferring property. So with regard to when transferring property ownership under a trust from current owner to a trust, lawyer answer is it depends. It depends on the circumstances.
Thanks. A lot of questions coming in now. Gina asks, any language recommendations when your parent or a person says they don't care about what's done because they don't have real assets?
Yes, because that comes up a lot. Like, oh, I don't have anything, it's fine. Like, oh, okay. Do you have a car? Do you live somewhere that you own? Do you have a checking account? If you do, you need to do your planning because there's nothing worse than having to probate a tiny checking account where that's money that could help the family, that could be utilized for a variety of, expenses and all that. There's nothing worse than having a small amount of assets and having them have to go through the court system and be whittled down with the fees, with the costs, all of that, thus reducing the tiny amount that this person's beneficiaries or heirs would have gotten otherwise. So I would say it's easier than you think, and it's more important than you think. If you really don't have any assets, if you don't really think you have any assets, you may have more than you think you do. And it's a worthwhile endeavor to plan for that.
Yeah, are there, this is a follow-up, are there any resources, maybe through the AARP website or something where it kind of lists where you could go through and say, even down to the smallest asset, here's the list of what we should go through?
I'm not sure that AARP provides that granular of a resource, but I would recommend if you Google my name, I've written some articles for AARP on this topic, and it'll take you to my family caregiving expert bio, and there you can kind of search through and look for articles I've written on the topic.
So, Deborah asked, what are the benefits of a trust? And I wonder this as well.
It depends. So it depends on what you are trying to accomplish. Sometimes we have trusts for tax reasons. Sometimes we have trusts to provide for our loved ones with special needs or disabilities that they are receiving benefits and we don't want to get them kicked off of those benefits, but we still want to provide money for them. There are reasons why people would create a trust to have some control over how the money is distributed. To let people live in property for a certain period of time, and then when they no longer need it, then having other people inherit it. If somebody has addiction issues or is otherwise just lousy with money, a trust can control it. If you have a spouse that is disabled or a spouse that you want to provide for, but you also have children from other relationships, tons of reasons to create trusts. It's just not an always do thing. And so it really has to make sense for your planning.
Thanks. Janie would like to ask, is it best to have one person be legal and medical power of attorney?
Necessarily. Some people may be great in a medical setting, just on top of things, but not have the organizational skills to make sure that your bills are paid and that they're getting the Medicaid application processed and things like that. So really think about people's skill sets, where they shine. It can be the same person. It doesn't have to be the same person though. But like I said earlier, if they are two people that do not get along, in a caregiving capacity, they would be having to necessarily work together.
Finally, Janice asks what an unfunded trust means.
An unfunded trust means that a trust is intended to manage assets. And if there are no assets that are titled in the name of the trust, or assets aren't directed to your trust after you pass away by way of your will or a beneficiary designation, then it's just a document. It doesn't control anything until those assets become a part of the trust.
Thank you. And then we had some questions about actually the functionality of this webinar. So just a reminder, since it's a webinar and not a Zoom meeting, attendees won't be able to actually see each other. They're seeing speakers, but you can talk to each other in the chat. And then obviously you can ask questions in the Q&A. That's all for now. I'll monitor. It looks like we have some resources coming in, Amanda, so I'll hand it back to you to close up.
I'll close out with some resources. AARP Advanced Directives, which we talked about earlier. Here is the QR code for this resource. The Family Caregiving Guide, which I believe is going to be discussed in greater detail further today. It's an excellent resource. I would strongly recommend utilizing it as a template and a tool when you're anticipating caregiving, or even if you're already in the stream of it, there may be things in there that you have not even considered. Lots of articles on legal planning. Some, if not all of these, have been written by me. And so if you read something that I've written and you have further general questions, feel free to reach out and I'm happy to discuss at any time. Additional AARP resources. There's so much for caregiving. The AARP Caregiving Facebook group. If any of you are active caregivers now, I strongly encourage you to join this group. It is the most supportive corner of the internet, and people go on there to share ideas, to ask for help, to look for resources, to sometimes just vent, and all of it is so supportive and helpful. I am on there. So you can also find me on there as well. The AARP Caregiving Resource Line, that is a phone number you can call, and they will direct you to resources that can assist. Medicare, Medicaid, long-term care help, extremely important for many families. That is available too. Financial planning resources, budgeting resources. And then you can order the AARP Family Caregiving Kit, which has some financial resources, home life resources, the Family Caregiving Guide, and more. So you can email askcaregiving@aarp.org to request your copy of that. And we welcome your feedback today. And thank you all so very much for having me.
Thank you, Amanda. I just want to, thanks so much. It was great. I am on the Facebook group as well. Veronica sent me there. I'm already like writing an email to Ask Caregiving because I would love some paper copies. And then anyone who's on the webinar, we will send out the slides as long as the presenters are okay with that. And then we are also recording our webinars today. So I'm going to stop the recording for this session. Stop.